Buckle up, guys. Today we're diving straight into a courtroom moment where the case doesn't ease in, it detonates. Before emotions, before excuses, the number hits the record $120,000 in reported income. That single figure immediately reframes everything that follows. This isn't a debate about effort or intention anymore. It's about math, statutes, and consequences. From the opening seconds, you can feel the pressure building because once income is on the table, the law doesn't blink.
The contested case. I have an opening. Your Honor signed a order in a suit affecting the parent-child relationship in 21. Child support was set at that time at 800. Government medical was ordered. Medical support was set at $75. The state is seeking a modification and we meet the statutory requirements. It's been at least 3 years, and the evidence will show that this case qualifies for an upward modification. Next, we'd like the court to take judicial notice of Ms. Martinez's presence in the courtroom. She has agreed to waive service.
Okay, so noted. Go ahead and proceed.
Your Honor, I will call the mother. Ma'am, can you state your name for the record?
My name?
Yes.
Naomi Berenice Martinez Contreras.
Now the courtroom shifts gears as the mother takes the stand, and what stands out isn't confidence, it's uncertainty. She hears the proposed increase and hesitates, clearly unsure what's happening or why. This is where many cases wobble, because confusion can derail momentum. But the court keeps moving forward, tightening the questions, narrowing the focus. This moment shows how quickly personal understanding becomes irrelevant once the process starts rolling.
Ma'am, can you state the name of the child in this case?
Yes, Javielita de Matamoros.
And she lives with you?
Yes, ma'am.
And how old is she?
She's 5 years old.
Ma'am, the state is asking for child support to be set at $1,510. Are you in agreement with that?
No, I'm fine.
Is that a yes? You want that to be changed to that amount?
If it's change is I don't understand why will be changed, or maybe because I hear he I know he paid all bills by himself, but I think he can pay it. So
Objection non-responsive. Your Honor, I request to ask the question a different,
oh, okay.
simple way.
Yes,
No,
ma'am.
yeah, yes.
Pay attention here, because this is the quiet turning point. After hesitation, after confusion, the mother ultimately agrees. The increase, the medical support, all of it. There's no dramatic speech, no argument, just acceptance on the record, and that matters. Once agreement is stated aloud in court, it hardens into fact. By the time the father is called, the foundation has already been poured, whether he realizes it or not.
That's fine.
Oh. I'll restate my question. Ma'am, if you can just listen to my question and answer that question only,
Okay.
okay?
Yes, ma'am.
Okay. Do you understand that child support was $800 before?
Yes.
Today, the state of Texas is asking that we increase that to $1,510. Do you understand that?
Yes, ma'am.
Do you agree with the state's request to increase it by that amount?
Yes.
The state is also asking for medical support to be increased to $250. Are you okay with that?
Yes, ma'am.
Do you have any private insurance available for your child?
No,
Your child is currently on Medicaid, is that correct?
yes.
Ma'am, you understand that the state used information reported to us to calculate this account. Do you understand that?
Yes, ma'am.
I pass the witness. I call the father. Sir, can you state your name for the record?
Francisco Javier Matamoros.
And sir, do you have any other children besides this child?
No, ma'am.
Okay. And sir, is it true that the child is currently residing with the mother?
This is where the numbers stop being abstract. The father takes the stand, confirms employment, confirms stability, confirms the income report. No extra kids, no missing data. Everything lines up cleanly. The court isn't guessing anymore, it's verifying. Each confirmation tightens the calculation, closing doors to flexibility. This section feels calm, but it's lethal because once income is undisputed, the outcome becomes increasingly difficult to escape.
Yes, ma'am. It's true.
And sir, is it true that you work for a waste company?
Yes, ma'am. West Community Waste Deposit, CWD.
Okay. And you've been working with them for a few years, is that correct?
It's gonna be 2 years this year because I'm coming from West for the company. It's gonna be 2 years in this company right now because I left and come back.
Okay. And you understand that your employer reported to my client how much money you make every quarter. Do you understand that? Is that a yes?
Yes, yes,
And
yes.
you understand, and I explained to you that before taxes, your employer is reporting that in the last 4 quarters, that you made $120,550. Do you understand that?
Yes, ma'am. Yes,
And that the state used guideline support of $10,045 a month to calculate your support. You understand that?
I understand that.
Okay, sir, let's switch gears a little bit. Do you have any private insurance available to you at your job?
I don't have nothing for that. I don't get anything to that. Just for pay for my daughter. I work for my family, for my daughter. I don't have nothing health insurance for myself.
Okay, so knowing all of that information, do you agree with the medical support being increased to $250?
I do if she give me the when the recipe when she take to the doctor when my daughter is sick.
Now the tone shifts from math to frustration. The father explains his grievance, not about money, but about access. Medical information, doctor visits, insurance details. He agrees to pay more, but only if transparency exists. This moment reveals a deeper conflict beneath the numbers: control, communication, and mistrust. It's the first time emotion cuts through the procedure, and you can hear how boxed in he feels by the system and the situation.
Or when she need go to see the dental, medical, or vision exam, because I asked him for her, can you provide me the information for me? And she said never, no, because I'm the mother. If I want it, I give it to you. If you don't, I don't, and approve it. So that's one of the five we had, or the argument, because she never approved it for that. I'm agree will will pay, but if we pay both right now, half and half, while that increase right now, because I was okay what I was paying, but she never provided me the information when I needed because my dad is always sick for some reason, but she say it's my fault, so I want to take to the medical center, but she never provide me the information from me, so I'm a lockdown with my hand because she never do that for me. But
Okay,
if it's she,
thank you.
okay, go ahead.
I'll move on to my next question.
Mhm.
Sir, are you in agreement with the increase of $1,510 for child support?
No, no, because but by the time when this happened, the first time when we had court, uh I was in the apartment. The bill it was less what I pay right now. I almost paid 3 times more what I was paying and what I was living by that time when I had the agreement, the first agreement. Now I got all the proof what I'm paying. If the judge had the time to see it, I can pay the same or a little bit more, $100 more, but I can pay the amount what you're saying because
This is the emotional peak. The father pushes back hard. explaining rising bills, living alone, and the fear that this increase could cost him his home. It's raw, it's personal, and it's relatable. But emotionally powerful doesn't mean legally persuasive. This is the moment where reality and law start drifting apart, and you can almost feel the outcome slipping away as the argument leans on hardship instead of statute.
I'll pay house, all my bill myself. She live with her mom, with her sister, so she live with three families in the same house. I live with myself in my house. So I provide everything for my daughter when she stay with me. And her, she not pay the food bills and the house where she live. So I can work with that, but I can go all the money because I had to figure out I lose my house or pay what the money is for my daughter. I'll go for the right thing, man. And the judge, if you're here, I'll for the right. Why did this right?
Thank you. I pass this witness.
All right. Well, I mean, I cannot take into account either one of your bills. So if somebody pays less bills or more bills, state law doesn't allow me to modify the calculation because somebody has less bills or more bills. What really it's coming down to here is you make twice as much as what you made before when we did your last court order. You're making 120,000. State law says what state law says is that it's a percentage of your income. It's 20% of your bring home income. And we start off with what your income is before taxes. We try to approximate how much you earn after taxes. What your monthly bills are, those are really irrelevant and are not part of state law as far as me being able to lower it. That could be argued all day long, but everybody's home care costs have gone up. I can't lower child support because it costs more for groceries. It costs more for groceries for both of you. So that's not really anything I can do to improve.
Here comes the cold water. The judge steps in and resets the room. Bills don't matter. Inflation doesn't matter. Living arrangements don't matter. The law only sees income and percentages. 20%, that's it. The explanation is firm, methodical, and unavoidable. But there's balance too. The judge corrects the medical amount and calls out the mother for withholding information. Authority meets fairness, and the decision solidifies.
So I have to go on what's been calculated and what's been reported. I know it's a big jump, but it's based on your current income. Your current income is about $10,000 a month, and so child support then comes out to $1,510 per month. Medical support will be moved to $250 per month. Um, I'm gonna change that. I'm gonna do medical support at $150 because we're going from the $75 to $150, so that's already doubling. I don't want to triple it. Ms. Martinez Mr. Matamoros is partially correct in that he needs a copy of the insurance card and he needs to know where your child goes to the doctor. He's entitled to both of those information just in case Mr. Matamoros has the child with him and there's an emergency and he needs to go to the hospital or doctor. He needs to have that Medicaid card or some kind of information, even a screenshot or something, so that he can use the insurance. You're supposed to be sharing that information with him. And then they also need to know what doctors the child goes to as well, so that if he has questions to the doctor, he can ask them directly and find out more. Because you're not a doctor, he's not a doctor. But he might have some different questions than you might have, and so he should be entitled to ask that doctor's office for some of the records and get that information. So you're supposed to be sharing that. Please share that with him immediately. Even you can just email him or text him. This is the name of his doctor or doctors, depending on how many doctors the child has. And then Mr. Matamoros, then once you know that, you should be able to call the doctor's office and get any documents you may need. Um, and you have a court order that also says that you have access to that information in the prior order. So that old order we did before gives you access to that information if they say they don't want to give you information. But I understand if you don't know the doctor, you don't know who to call. Ms. Martinez is going to provide that to you so that you have that, and then you can go and do your research if there's anything you want to look into. All right, that's the order the Attorney General's office is going to enter or give me for me to sign, and that'll be beginning February 1st. So no change for January. beginning in February. That'll be when the change starts. You have all of February to make the payment, so it's not like gonna be late on February 1st. But that's just we have to put it in the order that's the first of the month. So that'll be the order of the court. All right, y'all are done with court. You can press leave on the Zoom to exit out. Thank you.
Oh, can I say it? Can I say something?
No, no, it's gonna help me, ma'am. I've already
Okay.
made a decision. You're gonna provide the information to Mr. Matamoros, right?
No, but I had a question.
Hold on, hold
I
on,
don't
hold
hear.
on, hold on, hold on, hold on. I got a lot of people in here and I gotta get moving, but
Yes.
Mr. Martinez, you're gonna provide the information to Mr. Matamoros, correct?
Yes, sir.
Perfect. Mr. Matamoros, what question did you have before I let you go? Other than you don't agree with what I decided.
Yeah, that's what I'm saying. I don't hear how much I'll pay or what's the pay was to say because the way he was telling me, okay, I'm okay.
$1,510 for child support, $150 for medical support. That's what it is. That's what it should be. If you want to appeal my decision, you can, but that's the correct calculation. You may not like it, but that's the math.
The amount for the Medicaid is under the amount is for every month or is separate?
It's every month. It's separate from what you're receiving. You're not getting the 150.
Okay, so it's 1,000 1,510 per month
Yes.
plus for insurance.
Yes. All right. Got to move on. I got other cases to do. All right. Y'all can press leave to exit out. Thank you.
This is the final lock-in. The judge lays out the effective date, clarifies the monthly totals, and shuts down any last attempts to reopen the debate. 1,510 for support, 150 for medical. Every month. The frustration is audible, but the ruling doesn't bend. The case ends the way many do, not with agreement, but with arithmetic. If you found this breakdown valuable, make sure to like the video, subscribe to the channel, and we'll see you in the next one.